You're listening to the Bare Metal Cyber Prepcast, created to help you succeed in your educational journey. Learn more at baremetalcyber.com, where additional prepcasts, books, and training materials await. Let's get started. Domain V introduces state-level privacy frameworks and cross-cutting terminology that bind the entire field together. Unlike federal privacy law, which is sectoral and fragmented, state laws often attempt to create broader protections. This makes understanding state terms critical, as they frequently set new national baselines through enforcement or influence. Cross-cutting terms are equally important because they reappear across multiple domains, forming the glue that links federal, state, and even international regimes together. The glossary here covers both the recurring vocabulary of state statutes and the advanced terms that describe how privacy law adapts to evolving technologies, enforcement models, and global interdependencies. For learners, building fluency in these terms prevents confusion when multiple statutes overlap and ensures a consistent vocabulary for analyzing exam questions that cut across domains. These foundations prepare candidates to engage with privacy as both a legal and practical ecosystem. Federal state authority shapes much of Domain V. While federal law often provides sectoral coverage, states have filled gaps by enacting comprehensive consumer privacy statutes. Enforcement usually falls to state attorneys general, who act as the chief legal officers within their jurisdictions. These offices investigate violations, bring lawsuits, and issue settlements that influence business practices nationwide. For example, a data breach at a national retailer may trigger investigations in multiple states simultaneously. For exam purposes, candidates should recognize that attorneys general are critical state-level enforcers, ensuring that consumer rights are upheld even when federal law is silent. Their role highlights the decentralized nature of U.S. privacy enforcement and underscores why companies operating across states must navigate a patchwork of requirements. The California Privacy Protection Agency represents a more specialized state actor. Unlike attorneys general who enforce a wide array of laws, the CPPA was created specifically to oversee and implement California's privacy statutes. Its functions include rulemaking, audits, investigations, and enforcement actions under the California Consumer Privacy Act and its amendments. The CPPA's existence signals a new era where privacy enforcement is no longer simply an extension of consumer protection, but a standalone regulatory field. For learners, remembering the CPPA is crucial because California remains the most influential state in privacy, often setting standards that ripple across the country. On the exam, CPPA terms may appear in scenarios asking which authority has the power to draft regulations versus which enforces them, testing nuanced understanding of roles. Applicability thresholds are another defining feature of state privacy statutes. Laws often apply only to businesses meeting certain criteria, such as annual revenue levels, the number of state residents, data processed, or the proportion of revenue derived from data sales. For example, California's law sets thresholds based on both revenue and consumer data counts. These thresholds ensure that obligations fall primarily on larger entities or those heavily engaged in data practices, sparing small businesses from undue burden. For exam purposes, the term applicability signals the importance of analyzing whether a law even applies before diving into its specific requirements. Learners must remember that not all organizations fall under state laws, and recognizing thresholds can often be the deciding factor in applying rules correctly to a scenario. Statutory exemptions further refine scope by excluding certain entities, data types, or activities. For instance, data covered by HIPAA or GLBA may be exempt from state laws, preventing overlapping regulation. Similarly, nonprofits or government agencies may be carved out. These exemptions create important boundaries, ensuring that sector-specific laws remain the governing authority in their domains. For learners, exemptions highlight the layered complexity of privacy law. Compliance requires understanding not only what is covered but also what is explicitly excluded. On the exam, Exemptions may appear in questions where recognizing an excluded entity or data category leads directly to the correct answer. This reinforces the importance of careful reading and contextual awareness when applying state statutes. Consumer data subject rights form the centerpiece of state privacy statutes. These rights typically include access, correction, deletion, and portability, as well as the ability to opt out of data sales or targeted advertising. The scope and mechanisms of these rights vary, but the underlying principle is consumer empowerment. For exam purposes, key terms include the categories of rights and whether they apply universally or only under specific conditions. For example, California provides broader opt-out rights than some other states. Learners should focus on the structure of these rights, recognizing that while terminology may differ, the core function is to give individuals control over their personal data. Mastery of these terms prepares candidates to analyze scenarios involving consumer requests and organizational obligations. Privacy notice requirements are central to transparency. State laws mandate disclosures about what personal data is collected, how it is used, and with whom it is shared. Notices must often include consumer rights and instructions for exercising them. For learners, the key terms are transparency elements and required disclosures, emphasizing that notices are not optional or general but must contain specific content. Exam questions may test whether a notice meets statutory requirements or whether certain disclosures are missing. This reinforces the principle that transparency is a cornerstone of privacy, ensuring that consumers can make informed decisions about their data and organizations can demonstrate compliance through clear communication. Data protection assessments represent another critical term, requiring organizations to document risks and mitigation strategies for certain high-risk processing activities. These assessments may be triggered by practices such as targeted advertising, sensitive data processing, or automated decision-making. The documentation must analyze potential harms and demonstrate safeguards. For exam candidates, assessments illustrate the accountability principle, where compliance is not only about rules, but about showing thoughtful risk management. On the exam, questions may test whether a particular scenario requires a documented assessment, emphasizing the importance of recognizing both the triggers and the expected outputs of these processes. These terms reflect a growing global trend where privacy frameworks demand proactive analysis rather than reactive compliance. Data processing agreements bind organizations and their contractors to specific privacy obligations. These agreements, often required by state statutes, mandate that service providers process personal information only according to instructions, implement safeguards, and refrain from unauthorized use. For learners, the key terms include contractor obligations and scope of authority. Exam questions may describe a vendor relationship and ask whether a processing agreement is required. Recognizing this need highlights how privacy compliance extends beyond organizational boundaries into supply chains and partnerships. These agreements are practical tools that operationalize legal requirements, ensuring accountability flows through every layer of data handling. Data retention limits and destruction duties ensure that personal information is not kept indefinitely. State laws may require organizations to establish retention schedules and securely dispose of data once it is no longer needed, subject to exceptions such as legal holds. A legal hold pauses disposal when data is relevant to litigation or investigations, demonstrating how privacy obligations must coexist with other legal duties. For learners, retention and destruction terms highlight the importance of lifecycle management. Exam scenarios may ask whether data should be deleted, retained, or preserved, testing recognition of when privacy obligations yield to broader legal requirements. This reinforces the theme that compliance is rarely absolute, but instead involves balancing multiple obligations. Definitions of selling and sharing personal information vary across state statutes, but carry major compliance consequences. In some states, selling means any exchange of data for value, whether monetary or not. Sharing may specifically refer to targeted advertising practices. For learners, mastering these definitions is essential, since rights such as opting out of sales or sharing hinge on them. Exam questions may describe a business activity, such as transferring customer lists for marketing partnerships, and ask whether it qualifies as a sale. Recognizing how state laws define these terms ensures accurate application of consumer rights. These definitions illustrate how terminology, though seemingly simple, can reshape entire compliance strategies. State statutes also impose explicit data security requirements, often requiring businesses to implement reasonable safeguards. While reasonable is context-dependent, common expectations include risk assessments, employee training, and technical controls such as encryption. For candidates, the key takeaway is that state laws often convert what were once best practices into legal obligations. Exam questions may test whether a described safeguard meets statutory expectations or whether failure to act constitutes a violation. These terms reinforce the integration of privacy and security, reminding learners that protection of data depends on both legal compliance and operational rigor. Enforcement structures under state laws often include cure periods and penalty frameworks. A cure period gives organizations a limited time to remedy violations after notice, though some laws are phasing these out. Penalty frameworks define maximum fines and escalation mechanisms. For exam purposes, the key terms are cure and penalty, signaling the procedural pathways for enforcement. Learners should understand that enforcement is not only about identifying violations but also about how regulators respond, whether through corrective action opportunities or financial sanctions. This area demonstrates how legal design balances deterrence with fairness, creating both incentives for compliance and consequences for failure. Recent laws include health data rules that go beyond general privacy protections. Some state statutes now impose special obligations on health-related data not covered by HIPAA, including bans on geofencing near sensitive facilities like clinics. For learners, these terms illustrate how states innovate to address emerging risks, often in response to new technologies or social debates. Exam scenarios may test whether a particular data set, such as health app information, falls under these new state-level protections. Recognizing that health data rules extend beyond traditional medical records ensures candidates understand the evolving landscape, where privacy regulation adapts rapidly to societal concerns. Online tracking and cookie regulation represent another trend, as states increasingly impose rules around digital advertising practices. Requirements may include notice, opt-outs, or explicit consent for tracking cookies and other identifiers. These rules align with consumer expectations for transparency and control in online environments. For exam purposes, the terms tracking and cookie regulation are important, as questions may describe digital scenarios that test whether obligations apply. Learners should recognize that online advertising has become a focal point of privacy law, where consumer rights, business models, and state enforcement intersect. This area reinforces the broader principle that privacy law evolves with technology, requiring ongoing adaptation by practitioners. For more cyber-related content and books, please check out cyberauthor.me. Also, there are other prepcasts on cybersecurity and more at baremetalcyber.com. The California Consumer Privacy Act, strengthened by the California Privacy Rights Act, represents the most influential state privacy framework. Together, they establish broad consumer rights such as access, correction, deletion, and portability, along with opt-outs for selling or sharing personal information. They also introduce obligations for businesses, including data minimization, purpose limitation, and accountability requirements through risk assessments and contracts. For exam purposes, candidates should note that the CPRA not only expanded consumer rights, but also created the California Privacy Protection Agency, giving California both regulatory authority and enforcement power. These statutes illustrate how state law can approximate comprehensive privacy regulation, pushing organizations toward practices that resemble international frameworks like the GDPR, while still retaining uniquely American features such as opt-out rather than opt-in consent. The California Age-Appropriate Design Code extends protections specifically to children and teens. Modeled on similar initiatives in the United Kingdom, it requires online platforms likely to be accessed by minors to configure services with privacy by default, limit profiling, and avoid practices that exploit vulnerabilities. Terms such as platform obligations and age-appropriate design highlight the emphasis on tailoring digital environments to protect younger users. For exam candidates, this law shows how states move beyond traditional sectoral statutes to impose broad, proactive design standards on technology companies. It demonstrates the trend toward regulating not just how data is used but how platforms are built, reflecting growing concern about the intersection of privacy, safety, and developmental risks. The California Delete Act introduces requirements for data broker registration and expands consumer rights to demand deletion across multiple entities simultaneously. Data brokers, companies that collect and sell personal information without direct consumer relationships, have long operated with limited transparency. This law increases accountability by requiring public registries and enabling consumers to submit universal deletion requests. For learners, the critical terms are data broker and registration, underscoring the shift toward systemic mechanisms for consumer empowerment. Exam questions may test recognition of how this law differs from more general privacy statutes by focusing on actors outside the traditional consumer-business relationship. The Delete Act represents state innovation in tackling opaque data practices at scale. Virginia's Consumer Data Protection Act established a baseline for comprehensive state privacy statutes outside California. It provides rights of access, correction, deletion, and portability, while imposing controller duties such as data minimization and security safeguards. Unlike California, Virginia's law relies more heavily on opt-in consent for processing sensitive data categories. For exam purposes, candidates should compare Virginia's narrower scope and business-friendly enforcement model with California's broader, more aggressive framework. This illustrates how state laws vary significantly, requiring careful attention to statutory language and thresholds. Virginia's statute is important not only on its own but also as a model that influenced later laws in other states, shaping the emerging patchwork of U.S. privacy regulation. Colorado's Privacy Act adds unique elements by incorporating protections against unfair discrimination in insurance. Like Virginia, it provides consumer rights and controller obligations, but its inclusion of insurance-specific provisions highlights how states tailor privacy frameworks to address local policy concerns. For candidates, the term insurance unfair discrimination is particularly important, as it signals a departure from general privacy norms into sector-specific regulation within a broader statute. Exam questions may probe whether learners recognize how Colorado combines baseline rights with unique obligations. This law reinforces the principle that state statutes are not uniform templates but living documents reflecting regional priorities and industries. Illinois' Biometric Information Privacy Act is one of the most consequential state privacy statutes because it created a private right of action. BIPA requires entities collecting biometric identifiers, such as fingerprints or facial recognition data, to obtain informed consent, provide retention schedules, and protect data from misuse. Lawsuits under BIPA have resulted in significant financial settlements, making compliance a high-stakes issue. For learners, key terms include biometric identifiers and private right of action, emphasizing that individuals themselves can enforce rights in court. On the exam, BIPA illustrates how state statutes can create outsized impact, influencing corporate behavior nationally through litigation risk even though the law is geographically limited. California's Genetic Information Privacy Act extends protections specifically to genetic testing companies. It requires explicit consent for collection, use, and disclosure of genetic information, with provisions designed to mitigate class action risk. For candidates, the important terms are genetic information and compliance contours, emphasizing how states are targeting sensitive data categories with heightened protections. Exam questions may highlight the difference between GIPA and federal laws like GINA, testing whether learners can distinguish between employment-focused restrictions and broader consumer protections. GIPA demonstrates how states often go beyond federal baselines, adapting regulation to new industries where data sensitivity and potential harms are particularly acute. Automated decision-making and artificial intelligence governance are rapidly emerging cross-cutting terms. States increasingly consider regulations that require transparency, audits, or fairness checks for algorithmic systems making decisions about credit, employment, or access to services. For exam purposes, key terms include bias, audit, and governance frameworks. These concepts connect privacy with broader ethical and legal concerns about automation. Learners should recognize that while specific statutory requirements are still evolving, exam questions may test whether candidates understand the principles, namely, that automated systems must be monitored for discriminatory or opaque outcomes. This area reflects the expanding scope of privacy law into adjacent domains of technology and fairness. Do not call registries illustrate channel-specific privacy regulation at the state level. These registries restrict telemarketing communications, giving consumers the ability to block unsolicited calls. Some states extend these protections to text messages and other communication channels. For candidates, the important terms are registries and marketing limitations. Exam questions may test whether a scenario falls within the protections of do not call frameworks or whether exceptions apply. This area reinforces the idea that privacy law is not confined to data storage and transfer, but extends to everyday communications, ensuring that consumers retain choice and control over how organizations contact them. Breach notification laws are among the most widespread and variable state statutes. Common terms include definitional triggers, such as whether encrypted data counts as a breach, and timing obligations for notifying consumers and regulators. While all states now have breach notification laws, their requirements differ in scope and detail. For learners, recognizing variations is crucial. A company experiencing a breach must navigate multiple state laws simultaneously. Exam questions may present scenarios where timing and definitions differ, testing whether candidates can identify obligations under specific frameworks. These laws highlight the practical challenges of multi-state compliance, reinforcing the importance of precision in applying legal definitions. De-identification, pseudonymization, and re-identification risk are advanced cross-cutting terms. De-identification refers to removing identifiers so that data cannot reasonably be linked back to individuals, while pseudonymization substitutes identifiers with codes but preserves the ability to relink data. Re-identification risk acknowledges that de-identified data may still be vulnerable to being tied back to individuals when combined with other datasets. For exam purposes, these distinctions are critical, as compliance obligations often hinge on whether data qualifies as personal information. Learners should master these terms because they are likely to appear across multiple domains, not only in state law, but also in federal and international contexts. Sensitive data categories represent another recurring term, covering information such as health, biometrics, race, sexual orientation, or geolocation. State laws often impose heightened consent or processing conditions for these categories. For example, Virginia requires opt-in consent for sensitive data, while California expands definitions to include precise geolocation and union membership. For exam candidates, sensitive data is a signal that obligations are stricter than usual. Exam questions may test recognition of which categories qualify as sensitive and whether enhanced obligations, such as explicit consent or stricter security measures, are triggered. These terms reflect the broader principle that not all personal data is equal. Some categories demand greater protection because of the risks associated with misuse. Cross-cutting alignment with federal and international frameworks rounds out Domain V. State laws often must coexist with federal statutes such as HIPAA or GLBA, and with global transfer regimes like the EU-US. Data Privacy Framework. Key terms here include alignment and constraints, highlighting the need to harmonize compliance across overlapping regimes. For learners, this emphasizes the integrative role of cross-cutting terms. They allow practitioners to connect domestic laws with international obligations. On the exam, candidates may face scenarios where recognizing these alignments is essential to resolving apparent conflicts. This area reinforces the globalized nature of privacy, where state, federal, and international laws all shape obligations for U.S. organizations. By mastering the glossary of Domain V and cross-cutting terms, candidates gain fluency in the evolving state privacy landscape and the advanced vocabulary that binds multiple domains together. These terms not only prepare learners for exam success but also equip them for real-world practice, where state innovation, cross-jurisdictional variation, and emerging technologies continually reshape the contours of privacy law. Thanks for tuning in to the Bare Metal Cyber Prepcast, your trusted source for cybersecurity news and insights. Remember to subscribe at baremetalcyber.com so you never miss an update. And visit cyberauthor.me for best-selling cybersecurity books that equip you with expert knowledge. Until next time, stay secure and stay vigilant.